In 2021, a digital artist made 100 fuzzy, fur-covered NFTs of the Birkin bag, sold them online, and made hundreds of thousands of dollars off a bag he never touched, never bought, and definitely never owned. Hermès sued him. A jury said he owed them money, and the case ended up deciding something much bigger than one artist's little side project, whether trademark law applies inside the metaverse. In December 2021, an LA-based artist going by Mason Rothschild, real name Sunny Estival, released 100 NFTs called Meta Birkins. Each one was a digital image of a Birkin bag covered in colorful faux fur. He first showed them at Art Basel Miami, and sales took off from there. Hermès sued in January 2022, arguing this wasn't art. It was trading on the Birkin name and creating real confusion about whether Hermès was involved. Rothschild's whole defense rested on the First Amendment. His argument that Meta Birkins were artistic commentary on luxury and consumerism, the same way an artist can legally paint a Campbell's soup can without Campbell's permission. The court had to weigh a real legal test: whether using someone else's trademark in an artistic work is protected, or whether it crosses into explicitly misleading commercial use. In February 2023, after a 9-day trial, a Manhattan federal jury ruled unanimously against Rothschild: trademark infringement, trademark dilution, and cyber squatting on all 3 counts. The jury decided his NFTs weren't protected artistic expression. They found he intentionally tried to make buyers think Hermès was involved. Damages, about $133,000, split between profits from the NFT sales and cyber squatting damages tied to the metabirkins.com domain. A few months later, the judge issued a permanent injunction blocking Rothschild from profiting off Meta Birkins going forward and ordering him to hand over the domain. This was one of the first major trademark cases to test where NFTs sit legally. Are they art, or are they just a new packaging for a consumer product? The jury's answer: if you're using someone else's famous mark and creating real confusion about a partnership that doesn't exist, calling it art doesn't automatically protect you, digital or not. Rothschild appealed, and as of this recording, that appeal is still pending. Oral arguments happened back in October 2024, and the Second Circuit still hasn't issued a ruling almost 2 years later. This is not fully closed, and it's taking an unusually long time to resolve. A digital, fur-covered bag that never physically existed still ended up worth 6 figures in damages because the name attached to it was worth protecting. If you've ever wondered whether owning an NFT of a designer item means anything legally, this case is your answer, not without a very expensive lesson.